There is a year attached to what I was shown, not a window of time, not a range of possibility. A year, specific, precise, delivered to me on the other side of clinical death with the same clarity I once expected from evidence submitted in a courtroom. That year is 2026, and what is attached to it is the reason it took me 11 months to be able to say it out loud to anyone. I spent 31 years as a circuit court judge in Arizona. Before that, 12 years defending people's property rights in court. I know exactly how legal language is used to protect people, and I know exactly, with the precision of someone who has read 10,000 documents, how legal language is used to take things from people while making the taking look like procedure. What I was shown from the other side of death was not a vision, not a symbol. It was a mechanism, structured like a legal brief, and it has a target. I was clinically dead for 19 minutes. The medical record exists. The attending physician documented a systole on arrival. What happened in those 19 minutes is the reason I am speaking now. After a year of silence, I cannot get back. If you own your home, if you paid for it, if you have lived in it for decades, if it is what you have, I need you to hear what I was shown. Subscribe to this channel. There are more testimonies like mine, and I believe you are here because you were meant to be. And in the comments, I want to ask you one thing. Write the name of a neighbor you do not know. One name. One house within walking distance of yours. I will tell you why that matters more than anything else I say today. The last word I read before my heart stopped was foreclosure. I had spent my career fighting that word on behalf of people who could not fight it themselves. What I was shown when I died is that the fight is not over. It is just beginning. That is the year I was shown. Not a range. Not a possibility that might unfold over a decade if conditions aligned. A year. Specific. Attached to something specific. And what was attached to that year is the reason I spent 11 months unable to say a single word about any of this to anyone. Not my children, not my pastor, not the cardiologist who saved my life. My name is Raymond Whitfield. I spent 31 years on the bench as a circuit court judge in Maricopa County, Arizona. Before that, 12 years as a property rights attorney. I have read more legal documents than most people will encounter in 10 lifetimes. I know exactly how language is used to protect people, and I know exactly how language is used to take things from them while making the taking look like procedure. I am telling you this because what I was shown on the other side of death was not vague. It was not symbolic. It was not the kind of vision you can interpret in multiple directions depending on your mood. It was specific in the way a legal brief is specific. It had structure, it had mechanism, and it had a date. That date is 2026. I need you to understand who I was before I tell you what I saw, because if I had heard someone say what I am about to say before March of last year, I would have set it aside. I would have been polite about it. I am a Presbyterian. Culturally, not personally. I believed in order, in evidence, in the kind of truth you can put in front of 12 people in a room and defend. Anything else? Visions, prophecies, testimonies from people who said they had been to the other side and back. I treated the way I treated most things I could not verify, with respectful skepticism and quiet dismissal. I want you to remember that about me, because what I am going to tell you came to the last person in the world who was looking for it. The morning it happened was a Monday in March. My wife Margaret passed in 2019, so the house is quiet in a way it did not used to be. I had been retired for 4 years. I still kept my old schedule, up at 6, coffee by 6:15, at my desk by 7. Not because anyone was expecting anything from me, because I did not know how to be any other way. That morning I was reviewing a case file I had pulled from my own archive, a property dispute from 1994. A county in the eastern part of the state had attempted to seize a widow's land through a procedural reclassification. They changed the zoning designation of her property without direct notification, creating a compliance violation that triggered a forfeiture mechanism. She was 73 years old and had owned that land since 1961. I had overturned the seizure. It was one of the rulings I was most proud of. I had pulled the file because I had been reading some recent municipal code changes that reminded me of the same structural approach. I was sitting at my desk with the file open in front of me, coffee on my left, reading glasses halfway down my nose. The top of that 1994 document had the word "foreclosure" in capital letters across the header, which was standard formatting at the time. I was reading the county's original motion, and then the pain arrived. Not gradually. There was no warning, no tightness I had been ignoring for weeks. It was immediate and total. A pressure in my chest so complete it displaced everything else, every thought, every awareness of the room. I know now it was a left anterior descending artery occlusion. The cardiologists call it the widowmaker. I was alone in the house. My dog, a 14-year-old basset hound named Fletcher, began barking. He did not stop. My neighbor across the street, a retired schoolteacher named Carol, heard him through her kitchen window after approximately 20 minutes and came to check. She found me on the floor beside my desk. The paramedics documented a systole on arrival. No cardiac activity. Nothing. I was clinically dead for 19 minutes before they achieved resuscitation on the way to Banner University Medical Center. I coded 2 more times in the ICU over the following 36 hours. 19 minutes. I want you to hold that number, because everything I am about to tell you happened somewhere inside those 19 minutes. And everything that happened in those 19 minutes is the reason I am still trying to find the right words for what I saw, a year later, with 4 notebooks full of attempts, and still not fully succeeding. I did not experience leaving my body dramatically. There was no tunnel in the way you have seen described in films. What I experienced was more like a subtraction. The pain stopped. Not gradually, not with the relief you feel when pain medication finally works, but instantly, completely, as if it had never existed. And then the weight left. Not just the physical weight. I mean the accumulated weight of 31 years of decisions. Cases I had won. Cases I had lost. Rulings I was certain of. Rulings I have questioned every year since. The weight of trying to be fair in a system that was not always built for fairness. All of it left simultaneously. I can only describe it as having a filing cabinet removed from your chest that you had been carrying so long you forgot it was there. I was aware. Fully, completely aware. More aware than I have ever been in my physical life, including my sharpest days on the bench. I was not in my body. I knew this the way you know you are awake and not dreaming, not by reasoning toward it, but by the texture of the experience itself. And I was not afraid. I want to be clear about that because I think people expect fear in that moment. I was not afraid. I was, and this is the only word that fits, oriented. As if the confusion of physical life had simply stopped, and what was underneath it was available for the first time. What I saw next is the reason I am telling you this. And I need you to hear it, because I believe it was meant for you as much as it was for me. I became aware of a presence. I will not call it a figure because that implies a shape I could have drawn for you, and I cannot draw it. I will call it a presence because that is the most honest word. An intelligence that was not separate from where I was, but was the where itself, a knowing that was the atmosphere. And before I could form a thought, before I had oriented myself enough to ask anything, it was already clear that I was known. Not observed, known. Every case I had ever decided, every time I had applied the law correctly, and every time I had applied it in a way that served the mechanism over the human being. All of it present, not as accusation, as fact. And then I was shown something. I want to be very precise about this word. Shown, not told, not given a vision I could then interpret. Shown, in the way that a judge is shown evidence. You do not argue with evidence. You receive it. You assess it. You hold it against what you know. What I was shown was a legal mechanism. I understand how that sounds. I understand that if someone had described to me a near-death experience in which they were shown a legal mechanism, I would have raised an eyebrow. But I am a man who spent 4 decades inside legal language, and what was presented to me on the other side of death was organized the way legal language is organized. It had premises. It had procedure. It had structure that led to a conclusion. The conclusion was this. In 2026, a combination of Municipal Reassessment Authority, Federal Emergency Declaration language, and a new classification system for residential properties will be used to reclassify millions of American homes as non-compliant assets, not seized, reclassified. That distinction matters enormously, and I want you to understand why. When a government seizes property, there are constitutional protections, there are challenges available, there is procedure that can be contested. But when a property is reclassified, when its category changes, when it is moved from one designation to another through an administrative process, the protections are thinner. The mechanisms for challenge are slower, and by the time most homeowners understand what has happened to their property's status, the compliance window has already closed. I was shown this not as a scene playing out over a landscape. I was shown it the way you understand the structure of an argument when you have been reading law for 50 years. It arrived as knowledge, complete, precise, and attached to a date. I have spent the year since returning pulling every piece of relevant legislation I can find. Municipal code updates, federal emergency management language, property tax reform proposals in 7 states. I am not going to cite them by name or number because that is not what this is. I am not here as an attorney giving you a legal briefing. I am here as a man who died and was shown something and came back to tell you that the language is already being written. The people who will be most affected are not wealthy. Let me be specific about this because it matters. The mechanism I was shown is not targeting luxury real estate. It is targeting asset-rich, cash-poor households. People who own their homes outright, who paid off their mortgage, who have lived in the same house for 30 years, who have their equity and very little else. People who, if they receive a notice of reclassification with a compliance requirement attached, cannot afford to hire the kind of attorney I used to be. I was a property rights attorney. I know exactly what it costs to fight a municipal reclassification. I know what it costs to navigate the appeals process. I know that most of the people watching this cannot afford that fight. And I know that I spent 31 years on a bench deciding cases between those people and the institutions with the resources to outlast them. I did not always decide correctly. I know that now, in a way, I did not know it before. The presence on the other side did not tell me this as judgment. It showed it to me as fact, the way you show someone a record they have been keeping without fully examining. I want to pause here. I want to stop for a moment and ask you to actually receive what I just said. Not the prophecy, the admission. A judge, someone who held the law in their hands for 31 years, is telling you that the system he served is being used against you, and that he saw this confirmed from a vantage point that has no reason to lie and no interest in being polite. Let that sit with you, because the next thing I was shown is harder. At a certain point in the experience, I became aware of a boundary, not a wall, not a gate, a pressure, a knowing that beyond a certain point I could not go and still return. Everything I was being shown was on this side of that boundary, and I understood, with the same completeness with which I had understood everything else, that I was being shown it precisely because I was at the edge of going further and not coming back. The boundary is where I met the weight of this fully. I was shown a family. I do not know their name. I do not know the state they live in. They were shown to me as representative, as the face of the millions of households the mechanism will reach. A couple in their mid-60s. A house they have owned for 27 years. The address is on their children's school records. There is a tree in the backyard the husband planted the year his father died. There is a drawer in the kitchen where the wife keeps her mother's recipe cards. I watched. And again, watched is not quite the right word, but I was observing. I watched the process begin for this family, the notice that arrived, the language of the notice, which was technically accurate and completely incomprehensible to someone who had not spent years in administrative law. The husband reading it 3 times. The wife calling the county office and being directed to a website. The website leading to a compliance checklist with requirements that would cost at minimum $40,000 to meet. They did not have $40,000. They had their house. I have been carrying that family since I came back. I do not know their name. I could not find them if I tried. But I see the husband at his kitchen table reading that notice, and I feel the weight of every ruling I made that sent a notice like that. Legally sound, procedurally correct, humanly devastating. I want to tell you something that I was specifically shown at that boundary. The presence, that knowing intelligence that was the atmosphere itself, communicated something to me about protection. Not legal protection, not political protection. Something simpler and more durable than either of those things. I was shown people sitting at a table together. That is the exact image. A table. People who knew each other. Not organized around a cause. Not meeting to protest or coordinate or plan. Just sitting together because they were neighbors and they had chosen to know each other before the crisis arrived. I was shown that the families who will not be destroyed by what is coming in 2026 are not the families with the best lawyers. They are the families with the strongest community. People who have built relationships with the people on their street before the mechanism requires them to face it alone. Because the mechanism, and this is something I understood from inside the experience as clearly as I have ever understood anything in a courtroom, the mechanism depends on isolation. It is designed for people who face it alone. It does not function as effectively against people who face it together. That image, a table, neighbors, knowing each other's names before the notice arrives. That is the protection I was shown. Not a legislative remedy, not a court challenge. A table. I have thought about this every day for a year. I have thought about how to explain it to people without sounding like I am offering a greeting card in the face of a legal catastrophe. I am not. I am telling you what was shown to me with the same authority I would use to explain the structure of an argument to a law student. The table is not a metaphor. The table is a strategy. Because when a compliance notice arrives for one household in isolation, it is a legal action between that household and an institution with unlimited resources and time. But when the same notice arrives in a neighborhood where people know each other, where they have already sat at a table together, it becomes something different. It becomes a shared problem. And shared problems have shared resources, shared knowledge, shared the ability to find the one person in the community who happens to know administrative law, or who knows someone who does. I introduced myself to every neighbor on my block in the months after I came back. I had lived on that street for 27 years. I knew their house numbers. I did not know most of their names. It was the hardest thing I did after returning. Harder than the cardiac rehabilitation. Harder than telling my daughter what happened to me. I am a man who kept professional distance as a matter of character. Introducing myself to my neighbors at 71, explaining that I was the retired judge at number 43, felt like something I should have done in 1998. But I did it, because I was shown a table, and I understood what the table meant. Now let me tell you what it has cost me to carry this. There is a particular loneliness that comes with having seen something and knowing, with complete certainty, that the people you are talking to cannot fully receive it. Not because they are not intelligent, not because they do not want to hear it, but because the experience itself was not transferable. What I know from inside those 19 minutes is not something I can hand you. I can only describe it from the outside, the way you would describe a color to someone who has never seen it. I have filled 4 notebooks trying to get this right. Every attempt falls short. Not of the words. I have plenty of words, I spent a career using words precisely, but of the weight. The absolute absence of doubt that was present on the other side is not something I can replicate here. I can tell you what I saw. I cannot give you the knowing that accompanied it. And so I live with a gap between what I know and what I can convey, between the precision of the vision and the inadequacy of the description, between the certainty I carry every morning and the ordinary life I still have to move through, mowing my lawn, watching my grandchildren's baseball games, eating breakfast at the same table where I have eaten breakfast for 27 years. I'm not afraid of what is coming. I want to be clear about that. I was not sent back in fear. The experience was not a warning given in terror. It was shown to me with the same calm precision with which a competent judge reviews evidence. Here is the mechanism. Here is the timeline. Here is the protection. Now go back and do something useful with what you know. I was sent back for this. I do not say that comfortably. It does not sit easily on a man who spent his career being skeptical of people who claimed divine missions. But I have run out of alternative explanations for why a man who was clinically dead for 19 minutes was shown a specific legal mechanism attached to a specific year with a specific image of protection, and then returned to a world where the early architecture of that mechanism is already visible in municipal code updates in at least 6 states I have personally reviewed. Something is coming. You already sense it. You have sensed it for longer than you are willing to say out loud to most people. I know because the presence on the other side knew it too, knew who would hear this, knew who would recognize it not as new information, but as confirmation of something they had already been feeling in the marrow. You are watching this for a reason. Now here is what I am asking you to do. One thing, not 10, not a preparation list. One thing, before this week is over. Think of one neighbor you do not know. One house within walking distance of your own where you could not tell me the name of the person who lives there. Go and introduce yourself. Knock on the door. Say your name. Learn theirs. That is all. You do not have to explain why. You do not have to mention 2026 or legal mechanisms or anything I have said today. Just introduce yourself. That is the first stone of the table I was shown. If every person watching this does that one thing, if 1 week from now there is one more conversation that has happened between 2 neighbors who had been strangers, then something I was shown on the other side of death has begun to exist in the world, and that matters in a way I cannot fully explain but am completely certain of. The protection is not coming from Washington. It is not coming from a court decision. It is not going to arrive in a piece of legislation. The protection I was shown was already available. It was available the day you moved in. It is still available today. A table, your neighbor's name. Start there. If what I shared today reached you, if any part of it confirmed something you have been carrying without a name for it, I would ask you to subscribe to this channel, not as a favor to me. I did not want to be here. I wanted to spend my retirement mowing my lawn and watching my grandchildren play baseball and being left alone with my 4 notebooks. I am here because I was shown that I needed to be, and because my daughter sat across from me at the kitchen table one morning and said quietly that she thought other people needed to hear this. She was right. So I am asking you to subscribe because there are more testimonies like mine, people who came back carrying something specific, and I believe you are someone who needs to hear them. Not for entertainment, because something in you already knows that what is coming requires a different kind of preparation than most people are making. In the comments below, I want to ask you one thing. Write the name of the neighbor you are going to go and meet. If you already know all your neighbors, and if you do, you are already ahead of what I was shown, write the name of one person you are going to call this week that you have let too much time pass with. Just the name. Nothing else. Sometimes writing it is the thing that makes it real. I came back from 19 minutes of clinical death carrying a specific year, a specific mechanism, and a specific image of safety. I have done my best to set those down in front of you honestly. I do not know what you will do with them. I know only that I was sent back to say them, and that I believe this reached the people it was supposed to reach. Whatever is coming, and something is coming, that much I know without any doubt. I hope this finds you in time to build the table.